Hello everyone, this is Tom Fox, and I'd like to welcome you to episode 119 of the FCPA Compliance and Ethics Report. In this episode, I'll begin a two-part retrospective of all things FCPA, anti-bribery, and anti-corruption from 2014. I look at the corporate enforcement actions, the individual prosecutions, and the Eskenazi decision in this episode. The episode comes in at just under 20 minutes. I hope you enjoy it. Thank you for listening. Hello everyone, this is Tom Fox, and I would like to welcome you to this episode of the FCPA Compliance and Ethics Report. I thought, in view of the start of the new year, we might take a look back at some of the significant events, FCPA, anti-bribery and anti-corruption related of 2014, and see where that might be taking us going forward. So with that, let's get right into it, because the first thing that's significant is the numbers. We had 10 companies settle FCPA investigations, paying fines of a little over $1.5 billion. That is the second highest FCPA fine amount behind the year of 2010, I believe. We had 11 individuals indicted for FCPA offenses. We had several individuals giving guilty pleas or sustaining guilty pleas. We had the president of BizJet, a couple of directors, EVPs from Alstom, and then two more from Direct Access Partners. We've got a couple of pending criminal charges and trials, including the former CEO of Petro Tiger, and one of the four Alstom VPs left. 3 of 4 have pled guilty. Unfortunately, or fortunately, I suppose, for corporations, there are 11 declinations which we know about. What is unfortunate for the compliance practitioner is that we don't know really the facts around those declinations, because it's not made with public knowledge. As usual, there were some significant cases or enforcement actions, I should say. 4 very large ones that are worth noting, and some smaller ones as well. So with the large ones, the year started off with a bang in 2014 with the Alcoa case, which was a $384 million fine, including $175 in profit disgorgement. At that time, it was the fifth largest fine of all time, and number 1 in profit disgorgement. What we found out later in the year in remarks by Assistant Attorney General Leslie Caldwell was the fine could have been up to $1 billion, according to the Department of Justice. We had one guilty plea in this case. Unfortunately, it was the person who accepted the bribes, not the person who paid them, and indeed the third-party agent who acknowledged paying the bribes, Victor Dadala, he was the Serious Fraud Office in the United Kingdom attempted to prosecute him, and the prosecution absolutely collapsed during the trial, in fact, and his prosecution against him was dropped. So, very significant. Nevertheless, the next matter up was HP in April of 2014. HP was really stunning for a different set of reasons. HP first of all, did not self-disclose. The company, or rather the Department of Justice and SEC opened investigations after the Wall Street Journal broke the story about HP Germany allegedly paying bribes for sales into Russia, and the sales involved a $44 million sales contract for hardware to the Moscow prosecutor's office, which HP paid a $10 million bribe payment, which was funneled through a third party. Nevertheless, it was part of a really systemic and worldwide failure of internal controls, complete breakdown in corporate culture. If there was indeed corporate culture at this time frame when all of these events happened, we had a bribery scheme detailed in Germany, in Poland, and in Mexico. 3 separate enforcement tools used by the Department of Justice, a criminal plea in Russia and Germany, a deferred prosecution agreement in HP's Polish subsidiary, and a non-prosecution agreement, for reasons that still amaze me, in Mexico. The fine was $108 million, which obviously is quite a bit of money. Nevertheless, it was well below the minimum in the fine range under the sentencing guidelines. So the question is, how did HP really sustain such a low fine, given the complete and systemic failure of internal controls and apparently a culture that condensed such actions? Also, you had 3 separate bribery schemes in the German subsidiary. They used a third-party agent, and they funded the bribe by defrauding the corporate office through stuffing the channel of hardware sales through a multitude of distributors and then collecting the money. In Poland, the bribery scheme was the old-fashioned way. It was cash in a bag. Unfortunately for HP Poland, it was cash in the bag at the tune of $600,000 over 18 months. So you might ask the question of how did they fund this? Didn't someone notice 600,000 of our petty cash is missing? Apparently not. It was all paid in cash by the country manager to a Polish government official. In Mexico, a third bribery scheme was used. And in this situation, a Pemex purchasing agent demanded a 25% bribe for hardware purchased by Pemex. Apparently, HP Mexico agreed to pay this bribe and had an agent lined up to pay it. However, that agent could not get through the HP internal compliance process. Not to be deterred, HP Mexico simply appended him to a previously existing agent, increasing that previously existing agent's commission from 1.5% to 26.5%. For HP, no one in accounting or accounts payable talked to compliance, so there was no internal control over the increase in a commission rate and a payment of a bribe through that mechanism. HP has really not gone on the speaker circuit to tell us how they were able to sustain this fine. Nevertheless, it was apparently through its extensive cooperation with the Department of Justice after the investigation began and extensive remediation. So kudos to HP for doing this. However, they managed to do it. I mentioned the individual prosecutions. We have one that's upcoming, and that is the former CEO of Petro Tiger. Petro Tiger is alleged to have paid bribe to Ecopetrol, the Colombian state-controlled oil company. And there were 3 individuals involved: Joseph Siegelman, who has not pled guilty; Knut Hammarskjöld, a co-CEO with Mr. Siegelman, who has pled guilty; and the former general counsel, Gregory Weissman, who has pled guilty. Mr. Siegelman, as indicated, is actively defending this and may well go to trial. He is certainly throwing up all defenses that he can. It's very interesting that individuals rarely go this far, and we'll have to see how this might play out going forward. But back to some of the corporate enforcement actions. We really ended the year with a huge bang. That, of course, is the Alstom and Avon case. I've spoken extensively, or at least had a couple of podcasts on these cases, so I won't really go into the deep dive on them. But Alstom was the highest criminal fine of all time, second highest FCPA total fine, record settlement at $772 million to the Department of Justice. The company paid $75 million in bribes to earn $4 billion in contracts. The bribe payments were disguised using code names for both consultants and Alstom employees. The grand jury investigation was actively obstructed by Alstom. As I indicated in my talk on some of the individual prosecutions, there were these prosecutions led to Alstom becoming more cooperative with the Department of Justice. But really, you had a company with a complete systemic breakdown of internal controls, but probably more appropriately, a complete culture of corruption. In-house counsel was involved carrying out the bribery schemes and covering them up using code names. But one of the key points is the purchaser of Alstom, General Electric. GE has very publicly announced they're purchasing this company. This has led to a couple of very interesting things. One, there was no corporate monitor assigned to Alstom. Obviously, this is due to the GE presence, but also due to a World Bank monitor is already in place. And also, GE, it was specifically noted in the enforcement agreements that GE would not be paying this fine. It would be paid by Alstom. This, coupled with one of the 2 opinion releases from 2014, would tell us or gives us some indication of where the Department is going with successor liability. So I'll talk about that one a little bit separately. And of course, with Avon, we had a bribery scheme from 2004 to 2008, $8 million payments of systemic bribes to enter and maintain the Chinese door-to-door sales market. Cash, gifts, meals, travel, all used to fund these bribery schemes. There's really two-part to the Avon case. One was the actual bribery scheme, and the second was the cover-up. The cover-up came about because Avon's own internal audit discovered the bribery scheme. Senior executives ordered sanitization of the audit report and directed the auditor to destroy copies of the initial report. Avon is alleged to have spent upwards of $500 million on the the remediation and investigation. Clearly the highest cost of that, although it may be exceeded at some point by either News Corp or Walmart. Nevertheless, for $8 million in bribes, the company may have spent upwards of $750 million when it's all said and done. Senior executives were fired and were maybe prosecuted going down the road. So, pretty significant way for the Department of Justice to end this year on the prosecutions, corporate prosecutions. As I mentioned, though, that there were several significant individual prosecutions. I went into some detail about Mr. Siegelman, but there have been several more beyond that that I'd like to spend a little bit of time on because they provide some significant guidance from where the Department of Justice is going to be going. I think they're going to be going pretty hard at individuals going forward. And here we had 2014 some significant prosecutions, or at least enforcement actions. I mentioned obviously the Alstom, but we also had Direct Access Partners, two more. Direct Access Partners, the CEO and a former managing director, were charged and pled guilty in federal court to violating the FCPA by paying bribes to the Venezuelan National Bank. BizJet. As I mentioned, the former CEO, Bernd Kowalski, had been previously indicted, but he was living in Europe, apparently in Germany, and was not extraditable. He made a mistake, though, and that mistake was deciding to take a vacation where he would fly through Schiphol Airport. This was discovered through some form of surveillance, electronic or otherwise, and when he went to change planes at Lufthansa or SAS or KLH or whomever other terminal it was, he was arrested, and he was brought to the United States, where he later pled guilty in July. So clear showing that the Department of Justice will go after people that they have indicted. And I would think if you are a foreign citizen and you don't think the DOJ is going to go after you, you may be in for a very rude awakening, as no doubt Mr. Kowalski was. Finally, we had a very interesting prosecution around a fellow named Frederick Sillens. And Frederick Sillens is a representative of an Israeli company called BSRG, who is alleged, or at least is embroiled in an investigation around bribes paid to obtain a mining concession in the African country of Guinea. Mr. Sillens was the person who's alleged to have worked with one of the former wives, or now widow of the former president, to obtain this mining concession. It's alleged that he put together a series of contracts detailing payments to the former wife, now widow, of the former president. Mr. Sillens decided he needed to get these contracts back, and this widow had relocated to the United States, and he met with this widow at the Jacksonville airport, and unfortunately for him, she was wired up as a cooperating witness. And after he left the airport, Mr. Sillens was arrested. He was not arrested for FCPA violations. He was arrested for obstruction of justice because there was an ongoing FCPA violation. Ongoing grand jury investigation in New York over this matter. So he was arrested. He was arrested back in 2013, but he pled guilty in 2014. He had first tried to claim that the contracts in question, which bore the signature of the country manager of BSRG, were fakes. They were submitted to a forensic auditor for validation, and the contracts came back as valid, or at least not fake contracts. So he pled guilty to receive a 2-year sentence It is unknown or unclear if he will cooperate going forward or what the fallout might be for BSRG. BSRG later lost their mining concession in Guinea, and they are actively fighting that. So we'll just have to see how that plays out. The Department of Justice, not the Department of Justice, the Securities and Exchange Commission went after a couple of Noble executives back in 2012. Noble was one of the energy companies caught up in the Panalpina scandal of late 2000, first decade of the 2000s. Noble had pled out and agreed to a deferred prosecution agreement for its bribes around Panalpina and getting equipment into Nigeria. But the SEC went after two of Noble executives who were, one still with the company, one who'd retired. The initial allegations the SEC made were violations of anti-bribery provisions, internal controls, and false records, all relating to the FCPA. Civil action was filed against Mr. Mark Jackson and James Rulon through their directors and officers' liability coverage. They had counsel who aggressively defended this case. The case was whittled down to false records claim only on the civil side. No criminal actions against them. But immediately before trial, indeed the week before trial, the government settled with these two individuals. And they settled with them under the following terms. Mr. Jackson and Mr. Rulon agreed not to violate the FCPA going forward. So they agreed to a legal requirement that they currently have. This, in the trial lawyer world, when you agree to something that you already have a obligation to follow, that's called a loss. So kind of a black eye for the Securities and Exchange Commission going forward, and we'll have to see how they shake this out and moving forward against individuals directly on the civil side of FCPA enforcement. We had a very significant FCPA case out of the 11th Circuit, well-known case now called the Eskenazi Case. This is the first time a court of appeals had opined on the subject of whether a state-owned enterprise is covered under the FCPA as under an instrumentality. The 11th Circuit specifically rejected defense arguments that only an actual part of the government would qualify as an instrumentality, or that the FCPA should be construed to encompass only foreign entities performing core governmental functions similar to departments or agencies. The court created a two-pronged test, and it's the control test and the function test. The control test had 6 subparts, and I'll just go through these. The foreign government's formal designation of the entity, whether the government has an interest in the entity, the government's ability to hire and fire the principals, the extent to which the entity's profits, if any, go directly to the government's fiscal coffers, the extent to which the government's funds the entity if it fails to break even, and the length of time these indicia exist. Under the function test, or what does the entity do, are the following 4 prongs. Does the entity have a monopoly over the function it exists to carry out? Does the foreign government subsidize the costs associated with the entity providing the services? Does the entity provide services to the public at large and in the foreign country? And number 4, does the foreign government generally perceive the entity to be performing a foreign governmental function? So these 2 tests are basically how much does the government exercise control and what does the entity do within a country? The Court of Appeals made it clear that these prongs are not dispositive, that you could look at other prongs, you can develop your own prongs. Obviously, a compliance practitioner needs to follow these because it's going to be important to follow as closely as you can the case law. And if you stray too far from these, it may be difficult for you to argue, certainly in a court of law. Whether it is persuasive to the Department of Justice, of course, is a different question. It's really around control and what do they do. So those are the 2 things that you need to keep in mind. It's not the amount of stock or the amount of ownership. It's really those 2 questions that you need to focus on going forward. I'm at the end of my time here, and I don't want to go too far, so we're going to wrap this up as part one of my 2014 wrap-up. I hope that you will tune in for my next episode, which will be 2014 Year in Review Part 2. This is Tom Fox. If you have any questions, you can reach me at tfox@tfoxlaw.com. Thank you very much for listening.